Okay, these two cases, fairly recent cases. District of Columbia. Anybody know what District of Columbia is more commonly known as?
DC?
DC.
Sure, Washington, D.C. Yeah, good, Washington, D.C. This is the city of Washington, D.C. versus Heller as the defendant here. Okay? This case involved a Washington, D.C. law. Everybody knows that Washington, D.C. is not part of any state, right? It's not part of Virginia. It's not part of Maryland. It's right there on the Potomac, and part of the city, the District of Columbia. If you look at it on the map, it's like a square, a perfect square, right?
Yeah.
And they cut part of it out of northern Virginia and part of it out of southern Maryland, right?
Yeah.
Split by the Potomac, right? But it is not part of Maryland. It is not part of Virginia. Okay? It's a federal city, governed under the laws passed by Congress, but they have what we call home rule authority. They can make local laws. They have a mayor and a city council, for example, and they can make local laws, just like the city of Sugar Land can make local laws, or the city of Richmond can make local laws. Right? Okay, so they had a law in Washington, D.C., a local law, that made it a crime to possess a firearm, a gun, unless it was completely disassembled. The law in Washington, D.C. prohibited the possession or carrying of a firearm unless it was disassembled in a way that prevented it from being fired. The defendant in the case was arrested, tried, and convicted for violating that Washington, D.C. law, appealed the conviction on the grounds that it violated the defendant's Second Amendment right to keep and bear arms, and the Supreme Court agreed. In this 2008 case, District of Columbia versus Heller, for the first time, the Supreme Court rules that the right to keep and bear arms is an individual right. It's a right that's retained by individuals. There had been, over the decades before 2008, no shortage of opportunities for the Supreme Court to take up that question. Lots of cases coming out of various states and locations around the country that might have raised that question, but the Supreme Court consistently refused to hear those cases. They just would not take those cases up, leaving many people, many analysts, to conclude that the Supreme Court's view was that it's not an individual right, and they're going to let the states and local governments do whatever they think is necessary to regulate and control the ownership and possession of firearms. That's why, folks, I want you to understand, that's why, pay very close attention to what I'm about to tell you here, okay? That's why for very many years, the laws governing gun ownership and gun possession differed dramatically around the country. The ability to own and possess a firearm in Texas was much different than the ability to own and possess a firearm in, say, New York or Massachusetts. Right? Some of you are probably aware of that fact. One of the reasons for that, maybe the most important reason for that difference from one state to another, was the fact that the Supreme Court had never taken up a case in which it said that the right to keep and bear arms is a right that's retained by individuals. Okay? Defenders of gun control have for many years argued that it's not an individual right, that it is a right of, it's a collective right. It's a right of the community. And I think there's some credibility to that argument. Okay? I mean, you actually sometimes have to look at the language of the Constitution. If you read the Second Amendment, what gun rights advocates always conveniently forget to mention when they talk about the right to keep and bear arms is the part of the Second Amendment that says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And so then you have to put that in the historical context. The historical context of that amendment was that if we go back to the Revolutionary War period, right? The late 18th century, where every able-bodied male, free man, was part of the militia, and that when the call went out to defend, against a raid, for example, by Indians or by the French or whatever the threat was that was perceived, they could reach up and grab their handy musket from above the fireplace and fall into rank. So what I'm telling you is that gun control advocates, people who support the idea of gun control, view it that way. They're saying it's not a right of the individual, it is the right of the community to defend itself. All right? Gun rights advocates, people who advocate, full individual gun, they do see it as an individual right. Okay? I'm not telling you that one's right and the other's wrong. What I'm telling you is that for the first time in 2008, the Supreme Court sends a clear message that it sides with the gun rights advocates, that it sees the right to keep and bear arms as an individual right. It's a right that's retained by the individual, not by the community. Does that make sense?
Yeah.
Go
So, so one side is the gun rights activists, and then the other side is gun law activists.
Gun control advocates.
Gun
Yeah.
control.
That makes sense?
Yeah.
Okay. So, look, I don't want to belabor this point too much, but I think it's important for us to understand that at a fundamental level, what the debate over gun
The conference is about to end.
and has been for many years is this question of whether it's an individual right or whether it's a collective right. And I'm not going to try to resolve that for you, whether who's right and who's wrong.
Yeah,
but what I am going to try to tell you, and I want to make sure everybody understands, is that the Supreme Court is saying here in 2008 that it is, in fact, in their interpretation of the Second Amendment, a right of the individual. So if you want to think about it as a victory for the gun rights people, it is a victory for the gun rights people. I can promise you that the National Rifle Association celebrated this decision. Okay? Now, because D.C. is a federal city, it doesn't fall under the jurisdiction of any state. The question still remained whether or not states could impose restrictions and regulations. Okay? Was this right of the individual that the court is finding here in District of Columbia versus Heller, is it a fundamental liberty and therefore incorporated into the due process clause of the 14th Amendment? Remember that business that we talked about so much earlier in the semester? The doctrine of selective incorporation, the 14th Amendment, the provision that says, nor shall any state deprive any person of life, liberty, or property without due process of law. And we talked about how the Supreme Court had incorporated the right of free speech and it incorporated the right of free worship and so on. Right? Now here in 2010, this case comes out of the state of Illinois, the city of Chicago, and they had an ordinance that prohibited the sale, ownership of possession of handguns. Okay? And the Supreme Court says in 2010 that in fact it is a fundamental liberty and therefore the states cannot deny that right. Okay? Does that make sense?
Yeah.